Good morning, everybody. Thank you. Please be seated. And please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re Appeal of M.R. Case number 24 AP 128. Representing the appellant, M.R., is Carrie Johnson. Representing the appellee, Department for Children and Families, is Ryan Kane.
Thank you. Good morning, counsel. Come on up. If you would, for the record, introduce yourself and identify your client.
Good morning, Your Honors. My name is Carrie Johnson, and I'm representing the appellant, M.R., who's in court today.
Thank you.
DCF urges this court to hold that DCF has no duty to notify the person that it intends to substantiate and place on the Child Protection Registry, at least when that person is a child. If this court determines that DCF can list MR's name on the registry without providing any notice to MR, then DCF can list anyone on the Child Protection Registry.
I mean, you're characterizing it as no notice. There was notice. There was an effort made to give notice. Wouldn't you agree with that?
I would disagree with that, Your Honor, because notice needs to be reasonably calculated to provide actual notice to the person whose rights are affected. In this case, the person whose rights were affected was MR. MR's father had no legal interest in the outcome of DCF's substantiation decision. And there's a 1991 case that laid this out. It's In Re MC, and the citation for that case is 156 VT 642. In that case, this court stated, this holding has been repeated since in other more recent cases, that a person seeking to appeal a decision must have a legal interest in the decree that may be enlarged or diminished. MR's father had no legal interest in the decree, so he had really no standing to appeal on behalf of his son, and because he had no standing to appeal, sending a notice to him was improper. It wasn't reasonably calculated to give my client, MR, actual notice of the judgment, the potential consequences of the decision, and his right to appeal.
Well, would it be? I'm sorry, go ahead.
Let me ask it a slightly different way. Was there compliance here with 33 VSA 4916E?
Yes, Your Honor. There was compliance with the 4916E imposes an additional requirement on the state when the accused person is a minor child. 4916E requires that any notice required to be sent to the person who's been substantiated must also be sent to the person's parents or guardian.
The word also isn't in there.
It does not, you're right, Your Honor. It does not say also, but it also doesn't say instead of. There is nothing in that statute that says that DCF does not have a duty and an obligation to provide direct notice to the person who's been substantiated. And if you interpret the statute the way that DCF is asking the court to, what that would do is it renders the portions of 4916 and 4916A that talk about the person, the accused person, is referred to multiple times throughout both statutes, renders that all of those statutory provisions superfluous or ineffective. And we don't interpret statutes to create conflicts where a conflict in the statute doesn't need to exist.
Did you raise that argument below?
In front of the Human Services Board, I was merely responding to the department's motion to dismiss. So it was a responsive pleading. I don't believe there was a duty to raise every single possible argument against dismissal, only to respond to the department's very brief motion. It was less than 2 pages long, stating that they were dismissing or asking the board to dismiss because the appeal was untimely. I also notice is also an element of subject matter jurisdiction. As I explained before, the notice went to MR's father, who really didn't have any authority to initiate the appeal on MR's behalf.
So could I just clarify something? The notice was received by his father, but it was addressed to MR. Am I right about that, or was it addressed to his father?
I believe the notice was addressed to his father, and there were two notices. So this is an important point for the court to understand, is that MR's father does not dispute that he received the initial notice of the decision to substantiate MR in February, I believe, of 2022. MR's father responded to that notice by asking for an administrative review conference. The administrative review conference was held. The reviewer decided to uphold the substantiation because MR's father didn't attend the conference. And then the decision, according to DCF, there were no factual findings on this. This was all representations of the parties to the hearing officer. But according to DCF, they did mail the notice to MR's father, but MR's father could not recall receiving that notice and was not aware that there was another level of review before the Human Services Board. So when we found out in October of 2022 that the substantiation decision had already been made, and as soon as we learned of that decision, we requested an appeal before the Human Services Board. It was either that day or the very next day. It was less than 90 days out of time. So if this had been a superior court judgment, for example, under this court's rules, Rule 4C of the Rules of Appellate Procedure would allow the appeal to go forward because the appellant did not get notice of the decision at issue. The appellant, as soon as he learned of the decision, did timely appeal, and there was no prejudice to the department because the department would have had to stay this proceeding anyway because there was a pending delinquency in the.
Do you think that 4916E creates a presumption of a valid service when it's sent to a parent?
No, Your Honor, because the parent really isn't positioned to exercise this right on behalf of the child. Notice that's sent to a parent who may or may not even live with the child is not reasonably calculated to apprise the child of the issue. When the notice goes only to the accused child's parent, the message is that this appeal is for the parent. It's the parent's right to contest. It's not the child's right to contest. And that's exactly what happened here. That's exactly what MR's father thought. The letter is addressed to him. It describes this proceeding involving his son and then lists the rights, which he assumes are his rights, and he initiates but doesn't fully follow through with the process on behalf of his son without ever telling his son.
Ms. Johnson, and you just said that there was a pending delinquency action as well, correct?
Yes.
And M.R. was represented by counsel, I assume?
Yes. Yes, and the department did know that the delinquency proceeding was going on and did not direct notice of the substantiation decision to MR's counsel either.
That's not required, is it?
It's not required under the statute, but it certainly would have been a step that they could have taken to ensure that he got actual notice.
But M.R.'s parents didn't forward that letter of substantiation to his counsel, is that correct?
That is correct, Your Honor. There was no, the attorney was myself, and I did not know until October 5th or 6th of 2022 when I called DCF to ask why the decision hadn't come out yet.
We've held over the years that a parent has the legal authority to make legal decisions for a child. And we presume that they do that in good faith. Why is sending notice to a parent only then not consistent with that?
Well, a parent has never been able to waive their child's constitutional rights. They can't do it in a Chin's case. They can't do it in a delinquency case. They can't waive their child's Fifth Amendment rights. They can't waive the right to due process on behalf of the child because it is a constitutional right. I also think that if DCF is permitted to just send notice to a parent or one parent, which is what happened in this case, not even both parents, and you might not even actually be sending the notice to the parent who has legal custody of the child. The parent who has physical custody of the child and the parent who has legal custody are not necessarily the same people. Also, parents can have really conflicting interests to their kids. Like if you consider an example of the accused child being a sibling of the alleged victim, then perhaps the parent is siding with the victim against the accused child, and they have a real substantial conflict of interest there and are not going to be able to act in their child's interests or protect that child's rights. And DCF is arguing that in that case, in that example, the parent is really the functional equivalent of an opposing party to the child. And DCF's argument is that it's constitutionally and statutorily sufficient to send notice to essentially an opposing party with a significant conflict of interest. I do believe that whether this court analyzes the question or the issues here as a question of statutory interpretation, a constitutional challenge, or through the lens of good cause, the result is the same. And that is that MR's right to appeal before the Human Services Board, his right to a fair hearing, should be reinstated. There was obviously good cause because MR did not have actual notice of this decision. So he had no ability to control whether his appeal was timely filed. And this court has held through case law that when the circumstances are entirely outside of the person's control, that constitutes good cause.
What is the standard of review on the good cause issue?
It is abuse of discretion, Your Honor, and I believe that in this case, the Human Services Board not only abused its discretion, it just withheld its discretion entirely because these facts clearly warranted application of the good cause exception, and the
But
board.
it issued an order on it, right? About the late appeal. I mean, how did it withhold its discretion entirely when it looked at the facts and made a decision?
This is a clear-cut case of good cause, where the good cause exception clearly applied because my client had no ability to cause his appeal to be timely filed. So under those facts, the failure to apply the good cause exception was basically a refusal to exercise the discretion that it should have exercised to apply that exception to MR's case.
What about the issue regarding notice to the attorney or the attorneys that were representing in the delinquency proceeding?
There's no statutory requirement to notify the attorney unless the child is in DCF custody. But I think that the department, had it notified MR's attorney, certainly would have had a better argument that it was providing notice that was reasonably calculated to reach my client. Sending notice to the parent was not reasonably calculated, particularly when the notice is addressed to the parent. And but they didn't do that in this case.
But they're not required to do that either. Just thinking that just be best practices.
I do think that would be best practice. I think that the legislature recognized that people not getting notice of these substantiation decisions was a pretty big problem, and that's why there were some changes that just became effective on September 1st to the laws requiring DCF to make more efforts to get different types of contact information for folks and send notice via email as well as regular mail if the person requests that. DCF in this case has conceded that this decision implicates a protected liberty interest, and also that children have a constitutional right to due process. Yet their argument is that the person whose rights are at stake is not entitled to actual notice. And that is fundamentally inconsistent with 14th Amendment due process. And it looks like I am out of time.
Thank you
Thank
very
you.
much. Your time has expired, and we'll hear from counsel for the appellee. Please come on up and, for the record, introduce yourself and identify.
Thank you very much. Good morning, Your Honors. Mr. Chief Justice, and may it please the court, Ryan Kane on behalf of the Vermont Department for Children and Families.
Thank you.
We're arguing 3 points for the court today. First, DCF complied with the statutory notice requirements. Second, those statutory requirements are reasonably calculated to provide notice to a minor and therefore satisfy due process. And finally, the HSB did not abuse its discretion in finding that there was not good cause to extend the appeal deadline. First, with respect to the statutory argument, as this court has already articulated in the questions, that argument was not preserved below, and in fact, the opposite was conceded below. They conceded before the HSB that the statute only requires notice to the parents. And I think that indicates a clear interpretation of the statute. The title of 4419E is notice to minors, and it provides the mechanism for providing notice to minors, which is to send it to the parents.
But there is a good cause exception to that. You can reopen it if you can show good cause on why notice wasn't received.
Certainly, any appeal, any untimely appeal can be extended for good cause, and notice could be one reason for that, but not necessarily the only reason.
So wouldn't it be fundamentally fair to allow a hearing to go forward to just allow a juvenile to attempt to challenge the substantiation?
I don't think the question is one of fairness, Your Honor. This court has repeatedly held that failure to meet an appeal deadline, timely appeal something, is a jurisdictional issue, is very serious, that those deadlines are meant to preserve, the function of the judiciary and to ensure that appeals are timely brought. So the failure to timely appeal, there may very well be fairness for somebody to appeal any late decision, but this court has held that those are not merely, suggestions. Those are serious requirements that one timely appeal. And so the obligation to show good cause is a pretty high burden and requires that there be some extraordinary circumstances outside of somebody's control for why they failed to appeal within the time frame. And the HSB fully analyzed it. They certainly didn't withhold their discretion. There's a multi-pages of analysis considering that exact question of whether or not good cause existed, and it certainly didn't abuse its discretion in making that determination, and therefore this court must uphold that decision. Second, the statutory notice requirements adopted by the legislature are reasonably calculated to provide notice to the minor. It's just fundamental that parents are presumed to have their children's best interests at heart. They are the legal representative. They are the one authorized to make decisions on behalf of minor children. And so it's simply logical that notice to a parent is reasonably calculated to appraise the minor whose legal rights are represented by the parents of the hearings and the opportunity to appeal a determination.
But Mr. Kane, would you agree that there would be certain circumstances potentially where a parent would not be looking after one child's best interest in protecting another child?
I honestly think that's a pretty extraordinary thing to suggest, that a parent would be adverse to their own child's interests. A parent who has legal authority over the child with respect to something like being placed on the child protection registry. I think in the vast majority of cases, a parent, even when there's internal conflict between children, will seek to protect all of their children's interests fully. And so I think that's a pretty extraordinary circumstance, and one that certainly isn't presented in this case, and one that doesn't undermine the basic reasonableness of the notice requirement going to parents.
So it's possible, but not probable, is what.
Certainly, there's always possible unusual circumstances that, in this case, very well may be one of those. But the question before this court is whether or not the statutory notice requirements that the legislature have adopted are reasonably calculated to appraise notice. And fundamentally, I believe that they are, because of the presumption that parents do in fact represent their children and operate in their children's best interest always, in all of their children.
The reasonably calculated standard suggests that it's lower than actual notice.
Absolutely. This court has held multiple times that actual notice is not required by due process. In Hogaboom, I'm probably mispronouncing that, in other cases. So that includes, within that holding, is a presumption that there may in fact be situations where actual notice does not occur, but that doesn't create a statutory or a constitutional violation. And so
I have to ask a question, but I want you to finish this. I didn't want to interrupt.
no, thank you very much. I think that's all I have to say on
All
that.
right, so does it make a difference if there's a delinquency action that is based on these facts for the substantiation, and in that delinquency, the child is represented by counsel?
No, Your Honor, it doesn't. There's no statutory requirement. And fundamentally, those are two distinct proceedings. It may very well be the case that often the attorney representing a child in the delinquency proceeding may also elect to represent the child in challenging the substantiation and the registry determination, but that's certainly not always the case. And there's no obligation for an attorney to represent the child in both of those situations. So where there isn't a clear indication that the attorney is in fact representing the child in the other one, I'm not even sure it's necessarily appropriate. I mean, it's not inappropriate. I think again, I agree that extra notice, is generally a good thing, but that's not the question. The question is whether the statute requires it. And there is no statute that requires an attorney be represented. And that's different from other contexts. The legislature has made a determination with respect to these registry placement substantiation appeals that's different from other provisions in Title 33, the CHIN's petitions, the delinquency petitions. Some of those do in fact require notice to attorneys, and 4419E, when the child is in DCF's custody, requires notice to the attorney. But again, that indicates that the legislature intended to provide notice through the parent or guardian when the parent or guardian is the legal custodian of the child.
Thank you.
With respect to the preservation and waiver argument, it's simply not the case that every notice issue is jurisdictional and cannot be waived by failing to raise it below. And the cases that cited by the appellant in the reply brief don't hold as much. INRI JT dealt with the Indian Child Welfare Act. And in that case, actually, the court held that the issue was preserved, that the trial court had a full opportunity to consider the issue. And then essentially in dicta said, even if they didn't, based on the statutory provisions of the ICWA, that notice in that case was jurisdictional and therefore could be raised for the first time on appeal, but certainly didn't hold that every notice defect creates a jurisdictional question. And to hold that it does would actually undermine the entirety of this proceeding. Even the first internal appeal to the review unit within DCF by MR's father, apparently there was no jurisdiction to even issue that decision under their theory, because that notice is also provided pursuant to 4916E. So it's simply not the case. And again, Goss v. Lopez, the US Supreme Court case, also dealt with when notice is required and not the method of notice. And so it certainly doesn't support the proposition that any notice defect or argument about whether the method of notice adopted by the legislature is sufficient for constitutional due process purposes is a jurisdictional threshold question.
Does the fact that the appellant has conceded that notice was given properly to the parent moot out the argument that you just made about it being the argument that notice is jurisdictional? In other words, there's on one hand saying we have a right to appeal because failure to notify the child here was wrong, but then on the other hand, they agreed at one point that notice to the parent under the statute was correct.
Yes, Your Honor, I think that's accurate. So with respect to the argument, with respect to the statutory interpretation, that's the case. They did raise the constitutionality of 4916E below, arguing that it was not reasonably calculated to provide the minor notice and therefore violates due process. They raised that argument for the HSB, and the HSB fully considered it and found that the statute was constitutional. With respect to the overall argument that the statute is intended to treat minors who are listed on the registry differently from adults, that's just simply not supported by the statutory language of the provisions we've cited. But in fact, the rules from the department, which are cited in the HSB's decision, do treat minors differently and provide for much shorter periods for expungement and removal of any kind of effects of the listing. And so that is true and that is addressed in the rules, but that is not a reason to support interpreting the statutory notice provisions to say anything other than the plain meaning that the legislature intended with respect to those provisions. If there are no further questions, this court should affirm the decision from the HSB. Thank you very much.
Okay, thank you. Does the appellant have any time?
Appellant has no time remaining.
Thanks very much. Please call the conclusion of the hearing.
The next hearing for the court is